Harry Attwood operated a general outfitting business in the town of Kidderminster, near Birmingham in England. In 1909, Attwood employed James Lamont in his tailoring department. The agreement included a term that Lamont will not at any time hereafter carry on or be in any way directly or indirectly concerned in any of the following trades or businesses: the trade or business of a tailor, dressmaker, general draper, milliner, hatter, haberdasher, gentleman's, ladies' or children's outfitter at any place within a radius of 10 miles of the employer's place of business at Regent House, Kidderminster. Lamont worked for 10 years, but when they wouldn't make him a partner in the business, he left. He set himself up as a tailor in the town of Worcester, more than 10 miles from Kidderminster, but close enough to attract some of his old clients from Kidderminster. Attwood, the original employer, sued to restrain Lamont from trading, arguing that he was effectively trading within the 10-mile radius. A restraint of trade clause is all about balance. A healthy economy requires competition, and so a restraint of trade clause shouldn't be allowed to stop normal competition. However, it's not fair on employers if their employees can learn the trade at their expense, then leave and open up their own shop in competition with their previous employers. If that was the case, nobody would employ anybody. How could this balance be accomplished? Well, Lord Justice Younger outlined a number of rules, but the key one for our purposes was this: the party relying on the restraint of trade clause has to show that the restriction sought to be imposed upon the covenantor goes no further than is reasonable for the protection of his business. In this case, the restraint of trade clause was way too broad. It restrained Lamont from a wide range of business activities, not just tailoring, and there was no time limit. He was basically restrained permanently. Lord Justice Sankey said, "The covenant is essentially inappropriate to the attainment of any legitimate purpose of the respondent, while as it stands, it has not been justified by any evidence from him that his connection required so wide a restraint, or at any rate, a restraint so extended in duration. It remains the rule, 100 years later, that a restraint of trade clause will be invalid if it goes beyond what is reasonable."